Your Lordship, I'd like to mention item number 17. This matter may be adjourned and listed after 4 weeks. And I have taken consent from the PP.
Okay. 17.
17.
You are for the appellant.
Yes.
Your name?
T. Sigar.
T. Siga.
Yes, sir.
The prayer of Mr. T. Siga. Learned counsel for the appellant. Listed after 4 weeks.
4 weeks
Okay.
of life.
Madam, may I mention item number 15, Madam, supplementary hearing. Madam, counsel for the other party, senior member, Madam, Tony Patil. Today he is not available, so therefore, Madam, is consented by him. Matter will be listed day after tomorrow, Madam.
Item number
15, Madam.
15.
15, Madam. Of 2018 matter. Only 2 Madam.
What is the urgency?
Urgency is, Madam, it is subject, we are basically against the order passed by the ADC. And the very no exhaustive and no procedure has been followed. So straight away they rejected the affirmed the village authorities decision, Madam.
After 2 weeks?
It's consented by him, Madam. In fact,
Day after tomorrow.
day after tomorrow,
We are occupied.
Madam.
After
2 weeks.
2 weeks. On the prayer of Mr. M. Kartal and counsel for the petition listed after 2 weeks.
Madam. Much.
Your Lordship, I would beg to mention item number 12, 13, and 14 on behalf of petitioner advocate U. Bori, who is currently out of station. Who is currently out of station.
Yes.
Therefore, let the matter be fixed listed after 4 weeks.
What is the matter about?
Sir, my lord, it's a petition challenging the impugned JMFC order dated 18/1/2017 and sessions order 29/2017.
What is that order? We are not interested in date. Is there a stay order?
Actually,
No, it stays there.
No,
it stays there.
What is what are you challenging it?
it was a prayer of discharge. It's a prayer for discharge of GR case number 405/24.
Prayer for discharge?
Discharge of charge sheet.
Okay,
Your Lordship.
discharge of the accused was rejected by the trial court.
Yes, yes,
Correct.
yes.
Against that order, you have filed this petition.
Yes, my lord.
What is the stage of the trial?
Sir, your lordship, I was not instructed.
You may have been acquitted. This is 2017 matter, or you may have been convicted. You get those informations and come back while we take up the earlier listed matters.
Much
All right. What is the status of the trial? Trial is going on which court?
I am not aware of that, your lordship.
Then how are you aware of?
Here, your lordship, they are basically challenge the cognizance taken by the learned court below on the ground that under 468 there is a bar to taking cognizance. Limitation.
Or taking cognizance
Yes,
of
your
the.
lordship. Yes.
So you are saying that he is challenging the order of the trial court, dismissing his discharge application?
Challenging both the order from the trial court and the session court, your lordship.
Yes, your lordship.
Okay.
That was we have. My learned brother is very junior, your lordship. Perhaps he is not aware of the whole fact of the case.
But this is a 2017 matter.
Yes, your lordship.
You come back. What with an information, what is the stage of the trial? All right.
Yes,
Who is your senior?
U. Bori, your lordship. Uttam Bori.
Okay. Uttam Bori's name is second last from the bottom.
Yes, your lordship.
There are other senior counsels, senior than him. Okay, if it is Uttam Bori, you get an instruction, proper instruction. What is the stage of the trial? Isn't it?
Yes, your lordship.
Okay. After some time. Yes.
Much obliged.
Number 18.
Development.
Lordship made. Lordship, the applicant is taking anticipated bail, Lordship. In the FIR, that is 8/8/2023, Lordship.
Yes.
Lordship may, I may just take your Lordship to the brief facts of the case. Lordship, the dispute is regarding boundary, Lordship. The lane is not disputed. However, the boundaries of between the complainant and the private parties or on the applicant, Lordship, is disputed. Lordship, the dispute has been long back since 2003, Lordship. Arises since 2003, Lordship. In the authorities also, Lordship has already demarcated the boundaries. And a Kabang was also conducted on 16/1/2005, Lordship, wherein, Lordship, the title of the lane was given to me by that Kabang decision. And the complainant.
Okay, let us call for the case diary.
Lordship, I'm praying for an interim.
Why interim?
Lordship, I apprehended, Lordship, because the IO has been calling me, Lordship.
What is the allegation against you?
Lordship, the sections involved are 295, Lordship. Lordship, the dispute is of civil nature, Lordship. And
Civil
Lordship-
nature?
Yes. Lordship, and Kabang was
You
conducted.
are, how many JCB did you engage?
Lordship, I engaged one JCB, Lordship, that and JCB was engaged with the instruction from the Mandal, Lordship.
Huh?
On 7 of August, Lordship.
You read the FIR?
Lordship.
The accused person unlawfully encroached into the religious place with hiring JCB machine, damages and destroyed the security fencing, intent to grave the land in force. This is a civil dispute.
Lordship, this dispute is with regard to the boundary, Lordship.
See,
There already a Kabang.
see, there's no doubt.
Yes.
There is a boundary dispute between you and who is this? Donipolo welfare.
Yes.
Boundary dispute has to be resolved,
Yes.
is not it?
Lordship, it has already been resolved, Lordship. The demarcation order is already there. Since in the year 2004, Lordship.
So according to you, you did not employ JCB to damage and destroy the security fencing.
No, Lordship, the JCB did not enter into the
Okay,
premises of the.
that is why we'll look at the case diary.
Lordship, in the meantime, Lordship.
Which,
Trying for the.
just a moment, which accused person have you heard submitting before the court that the FIR is correct? That is why case diary is looked into.
Lordship.
And there is no doubt it is a civil dispute. There is not it. There is a boundary dispute between you and. But that does not authorize any of the parties to employ a JCB. JCB is a very dangerous vehicle. Huh?
Lordship, the JCB was deployed, Lordship, only to clear the forest, Lordship.
Let us,
So as to enable the Mandal to demarcate it properly, Lordship. It was on the instruction of the Mandal, Lordship. Lordship, may kindly have.
heard Mr. T. Time,
Lordship.
learned counsel for the petitioner and Miss L. Agarwal, call for the case diary. Fixing?
It's from each year, Lordship. So,
When?
it's next Monday, Lordship.
Monday, 21st of August. First of. Considering the allegation made in the FIR that the petitioner had engaged a JCB to destroy the security fencing of the religious place. What is the name of that place?
It is central.
Namely, no.
Only follow Ilam.
Doni Polo Gangung.
namely the government allotted area of Doni Polo Welfare Society Pasigat, opposite to Forest Colony area. How did the sentence start? Considering the fact that the petitioner had engaged a JCB machine, to damage and destroy the security fencing of the religious place. Namely, the government allotted area of Donipolo Welfare Society Pasigat, opposite to Forest Colony area. The prayer for interim pre-arrest bail is hereby rejected. Listed on 21st.
Item number 20.
20 is same order.
Yes, Lord.
Oh, same order.
Item number 1. Lordship, the pleadings are complete, Lordship. Pleadings are complete, Lordship. It may be fixed for hearing, Lordship.
Okay.
Matter may be admitted.
Mr. T time. Then with counsel for the appellant and Mr. L permit for respondent, all the respondent.
For one.
For one. Who else are there?
Respondent, the owner is also there, Lordship. Yes, respondent.
Just a moment. You are for respondent one.
One.
Two. Who is two? Owner.
Yes, Lordship.
Notice served.
Lordship, we have taken step under order 5 to substitute the manner, Lordship, by publishing in the newspaper, Lordship.
Okay. Appeal has been admitted.
Not yet, Lordship.
Huh?
No, not yet.
Then why you are saying that it should be possible hearing? You had taken steps in what? Condonation application. Is not it?
Lordship. Condonation the application as well as in mega application.
In the main appeal also.
Yes,
By which order you were asked to take steps in the main appeal?
8/5/2023 Lordship.
8/5. 8/5/2022,
2023.
2023.
Yes. The steps was taken on 12.
Just find out from here. What is the 8/5/2023? Sorry. Is there?
No, Lordship, the steps was taken in the IA.
Huh?
In the IA.
Condonation application.
Condonation application. Yes,
That was disposed of.
yes.
By which order?
26.
26.
26/7.
Yes.
Then this appeal was direct. That's why this appeal has come up for admission.
Yes, Lordship.
You are challenging which? Ever?
Challenging the implement award date judgment and order dated 4/6/2022 Lordship.
4/6/2022, is not it?
Yes, Lordship.
Okay. What was the award?
Lordship, the award was that the owner was directed to pay under the pay compensation to the claimant under MSCT, under the Motor Vehicle Act. And I was directed to pay compensation to the claimant under Workman Compensation Act. However, the application was under 163A, Lordship, of the MBA.
How much amount? 29 lakhs.
12,86,000 Lordship.
Page number? Oh, it was, okay.
It was splitted, Lordship, between the owner and me, Lordship. This is at page number 70 of the imprint that's been Lordship.
Oh, good. You are the owner of the vehicle.
No, Lordship, I am the insurance company.
Oh, yes, so you are the insurance company.
Yes.
How many opposite parties were there in the MSCT? MSC, okay, before the tribunal?
Two.
Two parties.
Two parties.
Yes. I was the opposite party number 2 and the owner was the opposite party number 1.
Okay. Second one was owner.
Owner.
Option number 2 was the
He
owner.
Yes.
He was the owner.
The judgment of the MSCT should type out the entire respondents, is not it? Huh? It is not there.
Yes, Lord.
You can't make out how many. It says SBI General Insurance Company Limited and others.
Right.
We don't know how many respondents are there.
Lordship, the offer to the owner was proceeded ex parte against.
Even then, Mr. P. Tai, learned counsel for the appellant, and Mr. L. Perme, learned counsel for the respondent number 1. This is an appeal preferred under section 173 of the Motor Vehicle Act 1988 against the judgment and award dated 4/6/2022 passed by the Motor Accident Claim Tribunal, West Kamen, Bomdila, in MSC case number 02 of 2020. However, a sum of rupees 29 lakhs 21,000 along with an interest at the rate of 6% per annum from the date of filing the claim petition till actual realization of the award, after deducting amount paid to the claimant under section 140 of the Motor Vehicles Act, has been awarded to be paid to the claimant jointly by the opposite parties number 1 and 2. Which amount has been specified as rupees 16,35,000 by opposite party number 1 and rupees 12,86,000 by OP number 2. You are OP number 1.
Yes, Lord.
Full stop. Admit. Call for the records. Issue notice to the respondents, returnable in 6 weeks. As Mr. Perme, learned counsel, has entered appearance and accepted notice on behalf of the respondent number 1. The issuance of formal notice is dispensed with, is hereby dispensed with insofar as the respondent number 1 is concerned. Poster. Extra copy of the appeal memo shall be furnished to him during the course of the day by the learned counsel for the appellant. Poster. The steps for service of notice upon respondent number 2 be taken by registered post AD as the usual process within a week. Poster. From paragraph. On perusal of the Judgment and award dated 4/6/2022. Passed by the MSCT West Kamen Bondila in MSC case number 02 of 2020. Though there appears to be more than one opposite parties, but the name and particulars of the rest of the opposite parties there appears to be two opposite parties, but the name of the opposite party number 2 has not been, but the name and particulars of the opposite party number 1 has not been described in the judgment and order, judgment and award dated 4/6/2022 by the learned MSCT West Kamen Bondila. Thereby making it not ascertainable by this court by looking at the by looking at the judgment and award passed by the learned tribunal as to who is the opposite party number 1. Question. Therefore, it is imperative to describe the name and particulars of all the opposite parties in the claim petition as well as the claimants by the motor accident claims claim tribunals when a judgment and award is passed on any MSC case filed before it. Also, therefore, motor accident claim tribunals are directed to describe name and particulars of all the claimants as well as the opposite parties in the judgment and award that may be passed in a MSC case filed before it also. Let a copy of this order be circulated to all the motor accident claim tribunals in the state of AP. Also listed after 6 weeks. What is IA?
IA, Lordship, IA is for stay, Lordship.
Huh?
IA is for stay of the imprisonment.
Stay.
Yes.
You want to stay?
It may be because they have not filed any execution petition.
Huh?
So, since they have not filed any execution
Okay,
petition,
you deposit 50% of the awarded amount.
so it may be heard together with the MA appeal, Lordship.
Huh?
It may be heard together with the main appeal, Lordship.
Main appeal.
Yes.
See, when the main appeal will be heard, Then what
Lordship,
use it will serve?
Lordship, the respondent number two, Lordship, the driver or the owner.
Then we'll dispose of it as not pressed. Huh?
Then Lordship may allow me to deposit the 50% amount, Lordship, with a condition that the claimant can withdraw the money or the amount, Lordship, by filing an appropriate application before this
Okay.
honorable court.
This you'll not withdraw. You'll withdraw.
No, no.
You'll not withdraw.
Well,
Okay. Huh?
I would like to withdraw my lord, deploy my lord. My lord, that's why my lord, earlier, I also submitted one citation, my lord. The intention of my lord, this legislation, my lord, legislation, my lord, ultimately the benefit of the claimant, my lord. Now, insurance company, my lord,
Mr. Tita, the counsel for the applicant. And Mr. L. Parveen, counsel for the OP number 1, stroke claimant. Applicant stroke appellant. This is an application for stay of the judgment and award dated 4/6/2022 passed by the London member MSCT Bomdila West Caming District in MSC case number 02/2020. However, an award of rupees 29,21,000 has been.
this part, my lord, will be my lord,
16 days.
16 next month.
Oh, just-
16 like that.
My liability is Lordship.
No, just 21,000 has been awarded. Not along with interest at the rate of 6% per annum from the date of filing of the claim petition till actual realization of the award has been awarded to be paid to the claimants by the opposite parties number 1 and 2 jointly, and the amount payable on the part of the applicant stroke appellant has been determined at rupees 16,35,000. Upon hearing the London counsel for the parties, the impugned judgment and award dated 4/6/2022 passed in MSC case number 02/2020 by MSC so and so shall remain stayed in respect of the applicant stroke appellant on deposit of 50% of the awarded amount before the registry of this court within a period of 4 weeks from today. Okay. Good. I distance
Lordship,
to
condition.
the extent indicated above and dispose of.
Lordship, I'm sorry to interrupt. Lordship, condition may be inserted, Lordship, saying that the awarded amount, the deposited amount of 50%, that can be withdrawn only by filing an appropriate application, Lordship, before this.
The
My lord,
option number 1 stroke claimant may file just after the appropriate amount is deposited by the applicant stroke appellant. The OP number 1 stroke claimant may file an application for withdrawal of the deposited amount, which have the full stop. If such an application is filed by the claimant stroke OP number 1, the same shall be considered in accordance with law.
I will.
I allowed to the extent indicated above and dispose of. Yes.
The regular person activity have been filed as per section 700 PPT. As per the cities, as per the provisions of 103, the memorandum of appeal is to be heard, and after that, the High Court is to draw the substantial question of law, and it should be formulated. Then the other party will participate in the argument upon the formulated substantial law. Now, here in the case is that before substantial question has been formulated by this court, they have raised an objection, they have filed. Now, on what basis the objection has been raised? Because till yet, the substantial question has not been formulated. Now, for the formulation of the substantial question of law, the ground of appeal memorandum is to be heard, and the fact is also to be narrated. Unless fact is known, unless ground is known, then how the substantial question of law will be drawn? Now, the substantial question of law is not to be drawn by the party, but it should be drawn by the court. Now, just for the background of the case, before coming to the ground of the
What, according to you, is the substantial question of law involved in this instant case? And how many?
Huh?
And how many? Second is how many? Yes.
substantial question of law, because the document which has been placed in the court that has not been interpreted properly. And whether party made an agreement between the party and they laid all the terms in place. Now, the person who made the agreement, who have signed it, admitting it, without disputing it, can he deny entirety of the content of the agreement? This is one point of law. This is a substantive question of law. Now, after making an agreement, I can say, no, this was not my content. It was not the right written. But men may differ his view, his opinion all the time. But document will never tell the lie. Here, completely an agreement was made. He has taken the amount. He says, completely he has deposed in the court. So that has been barred as per our section 91 and 92 of the TPC, Indian evidence, as well as it is barred by the estoppel also.
Where is the substantial question of law you have formulated? Where is the substantial question of law you have formulated in your memo of appeal?
Yeah, page 15.
Yes.
The substantive question of law arising in the instant appeal are as follows. Now, whether the unregistered document has completely lost its credential. Now, whether the witness can depose against the terms and conditions of the agreement. There are two agreements here in this case. One is mutual agreement. Here, the witness is stating, the own witness, plaintiff witness is stating that it was not the term and condition which was well discussed in the meeting. They have discussed separately in the meeting, but they have written it differently in the content of the document.
Yes.
So, as a witness, he can rectify, he can correct the content. Yes, it was the thing which were discussed. It was the thing which was not discussed. So that is the witness of the plaintiff. But plaintiff witness statement has been rejected. Now, another is whether a witness can be allowed to give evidence contrary to the content of document executed in between the parties. Here, the respondent and the present appellant and the one person, they have made an agreement. And he is also not disputing the agreement, but he has deposed in entirety against the content of the agreement. Whether it can be allowed, whether it is permissible according to the law. Now, another is whether the oral evidence without ambiguity and consistency statement is applicable in law.
Who was the plaintiff?
Plaintiff is
Okay.
a present respondent is the plaintiff.
What was the suit for? What was the suit filed for?
For declaration of the title of right title of the land disputed.
Okay. Then what did the trial court find?
Trial court finding, that is, they have found the
Suit was decreed.
Huh?
Suit was decreed.
decree.
Okay.
And
On
it
what
was-
basis?
And it was decreed in the senior division civil court, the CGM, and against of the order, we have filed an appeal before the district and session judge. And there also they said, so that's why we have come for the appeal under section 100 of the.
That is obvious, but what was the decree was based on? Suit was decreed on what basis?
Decree was passed because they have wrongly interpreted the document.
Which is that document? The plaintiff had relied on which of the evidence to prove his title, which the trial court has accepted.
Here, huh? Right. Then document. 194. The particular of the document is page 199. That is Dear give it 3.
190,
No, 199.
199. Agreement.
Agreement.
Yes.
Now, this agreement is made on 10 August 2010.
This is an agreement between plaintiff and the defendant.
No, plaintiff and a witness.
Okay.
But though he was a witness, but he was party to this agreement. In this agreement, he is the party. Sri Balamu, present of them side, G extension PO Nahorlogon, Papumpari district, Arunachal Pradesh of the one part. Srimuti Taki Mania, wife of Sri T.M. Tara, present resident of Model Village, PO Nahorlogon district, Papumpari, Arunachal Pradesh of the other part. Now, whereas both the parties entered into an agreement on following terms and conditions that on 7 March 2010, the second party and Sri Tabatakar, that is respondent, entered an agreement with the first party to borrow a sum of rupees 5 lakhs, only with interest of 5% per month from the first party. That the said amount of 5 lakhs was borrowed from the first party by the second party and Sri Tabatakar for purchasing land at Helipad Sector A. That the second party, Sri Tabatakar, who had agricultural land, a helipad, had no permanent path road to enter the said agricultural land. That both the second party and Sri Tabatakar has taken the loan from the first party for purchasing land so that they can use the land permanently without any hurdle as part of the roads to enter their agricultural land. That the loan which was taken by second party and Sri Tabatakar from the first party was not paid yet because Sri Tabatakar, who completely denied to pay any amount to the first party. That is the present respondent. That now all the burden come to the second party for payment of rupees 5 lakh with interest of 5% in total 6,25,000 only. That Sri Tabatakar, who completely denied no pay the amount which was invested to purchase the land for part public road, shall no right to use the part road from student. That the second party shall pay the entire amount of rupees 6,25,000 to the first party. So I have paid the 6,25,000. That the first party shall give the receipt to the second party as acknowledgement that the land area measuring 26,888 square meter, 2.6888 hectares of the land. Now, here, if Tabatakar, present plaintiff, was not involved, how this agreement was made and how the measurement of the present disputed land was come up. Now, but
Tabatakar was not a signatory to this agreement.
But since take of the case is there, that's why now before coming to the substantial question of it, we must know the background of the case.
Huh?
Background of the case.
Huh.
Background of the case is that I was requested to stand as a brother to take money from Parliament by the Tabatakar. Then I refused to stand as a brother, but on inquiry that what if you will not repay the money, what stand you will take? He clearly told me that you take my land. On the basis of that, the measurement of the land was also coming to picture. Then after that, money was taken by Tabataka. I become the guarantor. Being a guarantor, I paid the whole amount. Now, after repaying this 6,25,000, I applied for the NPC of the 8 lakh. And I was paying. I am holding the LPC. LPC is in my hand. So before the issuing of the LPC, there are many procedures which are to be adopted. When the procedure entered into the procedure was adopted, there was no irregularity, no illegalities. Nothing was found. So LPC was issued and it was found. Now, here in the case, the Balamu deposed in the court and he has stated that the amount was taken by testimony. The amount, like testimony. So my contention here in the case is that this is barred by, he cannot deny the entirety of the content of the document. That is barred under section 92 and 91 of the Indian Indian Act. So this aspect was not interpreted properly and it was not taken in the judgment. Because whatever Balamuk has deposed in the court, in contrary to this, the court has relied upon. So my contention is that had they not been relied upon the deposition made by the Balamuk, and if they relied upon the document written in this document, the content of the document, the judgment have been posed in my favor. Now, another document, that is one. Another document, I'll show you.
No, what has the trial court done with this document?
No,
This document was relied on for decreeing the suit.
no. Here in the trial court is there. Trial court opinion is there. Whatever Balamuk has deposed, without taking into the content of the document, they have relied upon the statement of the deposition of the Balamuk. So, can it be possible? As per law, it is not permissible.
Deposition of the Balamuk was contrary to this agreement.
Yes,
Okay. What this agreement in short is? This is an agreement between Balamuk and you.
yes.
Yes.
And here the disputed land measurement entirety is mentioned. And here they have mentioned the name of the respondent also. Because he refused to pay, because of that he has not been made as party. Here it is also in the content of the document. Why he has not been made? Because he has refused to pay. Repay back the amount, loan taken by him. And in my statement, I have clearly mentioned that 5 lakhs was taken by Palodi and 2,50,000 was he repaid for with the white law and 2,50,000 was spent by Tabataka. So I didn't get any money, though I stood as a guarantor. Although I repaid this amount, but I have not shared not a single price of that 5 lakhs.
Yes.
So since I repaid the amount, I brought the land under my possession. Then after I possessed the land, I obtained the LPC. After LPC, again they filed it.
Today we are here to frame substantial question of law.
Yes.
Okay.
Yes, substantial question,
Your
question of law.
argument has to be advanced, keeping that point in view.
No, my point is that it is the duty of the court to draw on the substantial question of law. But before drawing of the substantial question of law, court must know the background. That's why I am narrating it. So unless you know it, how court will draw the substantial question of law? Before drawing the substantial question of law, it is the duty of the court to hear the memorandum of appeal. Then another document.
So what is your submission on this document?
Huh?
Before we move on to another document.
No, my submission here in the case is that unless money was taken by Tata Bhatakar, this question or this document was not to come up. Since the document has been come up, in that case, if it is found to be valid, in that case, the title of the land should be declared in my favor.
That we will do it after, when we hear the matter finally, by framing a substantial question of law.
Yes, to come into
But
that.
after the argument so far advanced by
Yes.
you,
No.
with regard to this document that's at page 199,
Yeah.
what is the substantial question of law?
No,
First substantial question of law which you are which you are formulating.
Law, that whether I have read out the content of the substantial question of law also in this matter, that whether the witness can be allowed to give evidence contrary to the content of the document executed in between the parties. There is a question of law. It is a substantive question of law. To draw this very question of law,
Which one? At page 16?
page 63, whether the witness can be allowed to give evidence contrary to the content of the document executed in between the parties.
Which serial number you are on? Huh? Which serial number?
Page 16,
Yes, page 16, number 1,
3.
3. Let us begin with the 1.
1. I already started. No.
Already started. Court could not get anything about 1 and 2. You may have started.
No. I have started it. Whether the unregistered document has completely lost its credential.
This unregistered document which you have referred to, that refers to this general agreement at 199.
No, this is not the unregistered document.
Oh. So
Unregistered document is different thing. And now, there also,
you are proposing, Mr. Patin, you are proposing as many as 7 substantial questions of law.
yes,
So according to you, there are 7 substantial questions of law. So we'll hear on each of them. So if we find that yes, these are the substantial questions of law, we'll frame it.
no. Here,
So we'll begin with number 1.
here, whether the unregistered document has completely lost its credential. Here in the case is that there was an agreement between the appellant and the respondent. But while the document was not enclosed in the written statement, and the document was pressed out from the box of his son just before the argument, but it was a protested copy. That agreement, that copy is also enclosed here. In that copy, that I approached before our final argument, I approached the senior division civil judge. Then senior division it became late at number point. During number point, it was unregistered. Then again, after that, we approached the High Court as a civil division. As per that application was made under Order 8 Rule 1A of 3 of CPC. This during the pendency of the trial. the document was not in the possession of the present appellant. It was in the possession of his son, her son. Mean, after the death of her son, will they have checked all the document of his son, her son, they found that document, unregistered document. That has also been annexed. Unregistered document. Two 239. And then, but that application yes, come to the 272 page.
Hmm.
272.
272.
Hmm. Two seven two.
Yes.
Yeah. Deed of simple mortgage. I, Siri Tabatakar, present respondent, son of Siri Tabataki, resident of Model Village, POPS Naharlogon District, Papumpare, Onachal Pradesh, have received a sum of rupees 5 lakhs only for road construction from Siri Balo Muk, son of Siri Balo Tamin, a permanent resident of village Ria Balo, P.O. Gangte, P.S. Palin, District Kurungkume, Arunachal Pradesh, and presently residing at dam site, Naharlogon, P.O.P.S. Naharlogon, District Papumpare, Arunachal Pradesh, hereinafter called mortgagee, and having defaulting in repayment of the said land to mortgagee, and also upon the mortgagee's insistent, immediate repayment of the loan amount, or else providing security of movable property for securing the aforesaid repayment. I hereby effect the simple mortgage without possession in respect of with my land situated in a sector near Helipad Hanging Bridge, having total area of 26,888 square meters. Exactly, it is similar to the DB 3 hectares, and the boundary of the land is under north, south, east, west, schedule of the land, with all right of easement of appertain here to on the following terms and conditions: that the mortgage undertakes to pay the loan amount with interest thereon 5% per month of the said amount within the period of 3 months. This deed of mortgage. Here my name is not appeared now. Now that the mortgagor being defaulter in the aforesaid repayment of the loan amount with interest thereon. The mortgagee shall be free to enforce against the aforesaid land one and all the remedies of a simple mortgage. 3. That Srimati Tachimania, now my appellant names come up. Tachimania, residing at EE sector Nahologon, POPS Nahologon, district Papumpai, Onachal Pradesh is hereby stand as guarantor. Now they say their contention is that it is a mortgage, being it is a mortgage, it should be registered. So my contention is that it is not guarantor of Sri Tabatakar. That if Sri Tabatakar fail to return within the stipulated time, then Srimati Tachimania will be responsible for it. Now, the content of this is reflecting to the exhibit 3. That I, Sri Tabatakar, do hereby assure and declare that in case Srimati Tachimania repound the mentioned amount, then the land may be handed over to Sri Tachimania at the same cost. Now, in future, my relative or my family member shall not claim over the mentioned plot of land in near future. It was a disputed land. Now, this document was not we produced, but later on we trace out and we place it before the court. But it was not entertained. Then again, it was rejected. It was a stage of trial. Now, same original, we got it. And at the time of appeal, we approached to the appellate court for allowing us to produce the additional document. That is under Order 41, Rule 27. The stage, though, yes, 8183 is different stage and appellate court is different stage. So provision is also different stage. So this document was not unregistered and they were not relied. This is the unregistered document. So my contention here in the case is that even it may not be right, but it can be used in collateral evidence.
Suit was decreed on which of the evidence? Suit was decreed by the trial court on which of the evidence stand produced by the plaintiff?
Only on the basis of that, this document was not produced.
Which this document?
Now I have shown this 272 document, which I have read out. It was not unregistered.
272 is the agreement between you and Balamo.
Tabatakar, plaintiff,
272.
272.
That evidence has been relied on.
But even was not relied. This document was not produced. It was rejected.
We are not asking about which evidence was not relied on. Suit was, you said, decreed in favor of the plaintiff. By relying on which of the evidence?
Not the single document, relied document they don't have.
Then what was the judgment based on? Judgment of the trial court was based on what?
Judgment of the trial court was only that there is not a registered document.
Which one is not a registered document?
That's a document between the parties to transfer the land. And plaintiff has inherited the property, disputed property. My contention is that we are not disputing the inherited property. Initially, the land is inherited property of the present respondent. But since he was the owner, the land was inherited by him. Because of that, he has given me the land and land was transferred to me. By virtue of it is transferred.
Who had given land to you?
Tabatakar. Tabatakar.
Okay.
Present appellant.
Plaintiff.
Present appellant. No, present respondent.
Plaintiff had given a land to you.
Yes.
By which? By page 72.
But by
272.
yes,
Mortgage.
but mortgage. I repaid the loan of 6,25,000 to the Balamu. Now, but what Balamu says now? No, if amount was not taken by Tabataka, amount was taken by Techimania. So how will you believe this? How court can rely upon that statement?
Had Mr. M. Patil, learned senior counsel for the appellant, and Mr. K. Tama, learned counsel for the respondent number 1.
Sorry.
Oh, sole respondent. The substantial question of law proposed by the appellant in paragraph 19 of the memo of appeal lacks material particulars such as the description of the unregistered document which finds at serial number 1, and the terms and conditions of the agreement, and the material particulars of the terms and conditions of the agreement referred to at clause 2 of clause 2. Did I say N? Okay, don't semicolon. Documents executed between the parties referred to in clause 3 and agreement and documents referred to in clause 5 of paragraph 19 of the memo of appeal. Full stop. In that view of the matter, this appeal stands adjourned for 2 weeks to enable the learned counsel for the appellants to propose another sets of substantial questions of law involved in the instant appeal by providing the material particulars of the documents or agreements that may be referred to by the appellant for formulation of substantial question in law involved in the instant appeal. Full stop. List it after 2 weeks. You have a relook at this documents.
My lordship.
Yes,
My lordship, this is an application filed under 482, joint application between the husband and wife.
Yeah.
And I'm the husband and the wife.
yeah,
Both we have compromised and settled the matter outside the court, not to pursue the matter. Already agreement has been already been enclosed in page 40.
page 14,
40.
40.
Yes, agreement. This is a matter of husband and wife. My lordship.
Husband and wife.
Yes.
Then what happens?
Only there was some brawl and some incident took place. Thereafter, wife made a complaint before the it's another WPS where it was registered. And the matter has been now been going on in the trial court. And the section that has been deferred, 325 also, it is a comfortable offense if the party to whom the injury has been caused. This is the matter. Two sections are interpreted, 498A and
Where is
325.
the FIR?
FIR, if we go through FIR, you can see in page 12 to 16.
Hmm? Page
12.
12.
May I please?
Yes.
It is to inform you that since from the month of March 2016, my husband, Mr. Tamtanya, son of late Tamtale, resident of Daugum village, Bandadeva, POBS Bandadeva, Papukari district, Arunachal Pradesh, is constantly giving mental harassment, torture, and physical assault upon me, and he has also developed illicit relationship with another woman, namely Miss Hilang Yaju of Santi Colony, Bandhavgarh. Since from the mention about my husband has stopped supporting me and our two children. First child is age about 2.5 years and another is about 1.5 years. He is repeatedly causing mental torture and physical assaults upon me, which is beyond bearable. Date on 7/06/2016, at about 11 AM, my husband assaulted upon me by hitting with wooden stick, due to which I sustained injury on my right shoulder and my right shoulder was dislocated. That on 15/07/2016, at about 10 PM, again my husband assaulted me by pelting a stone, due to which my left hand is badly injured and fractured. Besides my elder child, namely Sri Tam Mangkung, who is lactic baby, has forcefully been taken away by my husband. The harassment, which is beyond toleration for me to sustain life with two child and without any financial help. On 23rd/07/2016, my husband made allegation against me that I was stolen clothes of Miss Hilang Yaju from her residence, which I do not have any connection. This is the allegation.
Then what happened thereafter?
And thereafter,
Charge sheeted,
my
charge
lordship,
sheeted.
yes, my lordship.
Where is charge sheet?
Charge sheet, if we come to charge sheet, it is on the page 17 to 39.
17 to 39.
Yes,
Under which section?
it is on 498A and 325.
Where is that? The relevant page?
Relevant paragraph, if we come,
Page
page number 27.
27. Yes,
That is the charge sheet.
okay. 325 is causing hurt.
Yes. And my lordship, 325 is componable also, the person against whom the injury has been caused.
Huh?
325. As per the section of 325, it says. the
When was
provision-
it filed? Charge sheet was filed 2016.
Yes.
What is the stage of the trial?
Now, on the
The
state.
record states that yet to commence with framing of charges. Your Lordship.
Huh?
Framing of charge. Your Lordship.
Charge has
Yes.
not yet been framed.
Not yet, correct.
What the court below is doing?
Yes, my lordship.
Why the charge has not been framed till date?
My lordship,
Which court?
JMFC. And interestingly, my lordship, again, my wife, she had made a complaint and filed a domestic violence case,
Hmm.
which I have not reflected in my petition.
Yes.
As per direction of this honorable court, I have furnished the bail bond of 20,000, and I was arrested and released later by PS Daporejo. And 120, as per one as per CRPC, 161 statement also reported. I'm ready to comply. The whenever.
What is the section?
Section, this is the section 3 of prevention.
PDPP.
Yes,
You have damaged the government quarter.
not exactly.
What have you damaged?
Yes, my lord.
What have you damaged?
This is actually government quarter, no? So they have alleged that I have damaged the government quarter.
Government quarter.
Yes. So this is my lord. I'm ready to face the trial if they have.
You have no option but to face the trial.
Even this section also, the section which is
Gradually, one by one. Let us see the FIR. If there are material against you in the case diary, no bail.
no, my lord.
This is an anticipatory bail, isn't it?
Yes, my lord, yeah, this the section which is the against me, that's a section which is involved, this against me, this is a section 3. This is actually, we have on the court, Arunachal Court, volume 8. They have not followed the as per procedure, the which Arunachal Court, this is a Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003. But here, the complainer is
This is a bail application.
yes.
Beginning of the bail application should be from the FIR.
Yes.
What is the FIR?
Yes. FIR, I have, this is my annexure A of page number 11 to 15. Page number 12, this is I type out.
You are Tago Sango Maing,
Yes.
by constructing a RCC structure. You have constructed RCC structure also. After dismantling and destroying government structure property. After having received a complaint, Anderson visitors. Yes, what is this? Case diary?
Is not.
FIR is dated. What is the date of the FIR?
FIR date.
6/7.
Yes.
From where do you find it? 6/7? Received on 6/7.
Yes.
Okay. What is this?
Lordship, that's a subsequent status report, Your Lordship,
Oh,
after
that was 24th July. Okay. This is
10th of August.
10th. Yes. What do you propose to do now?
My lord, last time, I have not given opportunity to submit the representation or reply. As per this, the section which is.
No, we are not on Public Premises Act. That is a civil proceeding.
Okay.
We are on PDPP.
No, that's why, my lord, here we have Arunachal Court. And this, as per Prevention of Damage Public Property Act, this is Central Act. So this should be, those who made a complaint against me, that is EAC, District Administration, EAC. And whatever, as at least the property, it is damaged, Arunachal property only, state property only. But this section, which is section Prevention of Damage Act, this is the another, as my understanding. This is for the public property, which is central property. If I damage it, this act should be against me. But as per the
You have not damaged the central property.
not,
You have damaged the estate property.
no, that's why the section which is against me, made this invoke against me. This is a section which is section 3.
PDPP.
Yes, it is. They have not followed the proper procedure.
What procedure is to be followed?
And as per the Arunachal Court, we have on the volume 8. It is the page number. This page number.
What act you are referring to?
I'm at this public premises.
We are not going to refer to that. Public, see, you have been booked under this Prevention of Damage to Public Property Act.
That's why, my lord, we have Arunachal on court made in the procedure how to make this follow as
Mr. Your name, Dukam.
per
You are not correct. That is for the public premises of eviction. That is the procedure to be followed for eviction of those who are in occupation of the public premises.
Yes, exactly. This is also related to.
So according to you are in occupation of a public premises. You admit to that
Yes.
by damaging one quarter.
No, I have not damaged the quarter. But here,
See, two things. If you enter upon a public premises by damaging a public property, two parallel proceedings can be drawn against you. One, the act which you are referring to for eviction of you. Second, a criminal case can be registered against you under section 3 of PDPP Act. So we are concerned with this PDPP Act, not that Public Premises Act. Have you understood?
yes,
Defamation has two parts, criminal as well as civil.
yes,
We are not concerned with the civil, we are concerned with the criminal.
my lord, they should follow the as per the procedure. They have this, the Arunachal has a court. Whether I have damaged the public property or not, I should be given the chance to the liberty to defense. As per the procedure, there's a section 4 of state official, so cause notice should be issued.
Yes.
And section here, there is a, if the state official.
They don't see, Mr. They don't intend to evict you from there. They intend to send you to jail by invoking Prevention of Damage to Public Property Act. They have no intention to evict you. You remain there, they'll send you to jail.
My lord, I have not encroached, not damaged or not done any against the.
Okay, let us now come back to your bail application.
Yes.
Yes, don't refer to Public Premises Act. Yes. I see, Mister, I'll tell you. There are various quarters lying there. I've seen the photographs. You are inhabiting which place? Dapur's Upper Sumaсе. This place of incident is where?
This is.
Dapur. Dapur is only.
Yes.
There are various quarters. Several quarters. You are aware of it.
Yes.
You have damaged one of the quarter. You are constructing an RCC structures there. It is not very big plot of land. Government can give you. Government can condone you also. But what will be the effect? Now your friends will start damaging the quarter nearby. Why? That government has not taken action against you. And your another friend will come and damage the quarter this side. So that way, gradually, the entire complex of the quarter will be occupied, will be damaged, encroached and occupied by various people. You are the beginning. Have you thought about this? Have you thought about this? The repercussions which your act will have in the area and to the people and the public at large.
And one more, if this.
It's another matter. You are very unfortunate. You have been caught. Huh? You don't have much luck in your favor.
My lord, if this court is permit, I would like to show the one photograph, which is just related recent incident only.
Where?
This is the portion of the building that is a landslide, which made against me. This only recent.
What do you? Okay, landslide has damaged this.
Yes,
Then
actually, I have not done anything but unnecessary my against. I don't know.
Now, what you propose to do? There are materials. You have invested some money also. You have erected iron pillars also. Column you have invested. If you are prepared to remove all those and hand over the back to the possession to the government, we will assume this matter for some time, and your interim bail will continue.
Yes, I'm ready to do that.
Is it
If-
noted?
if,
You better do that.
Yeah, if.
Otherwise, your friends will imitate you.
Yes.
Yes. So within how much time?
If so that if I have to erect the building, it will, if damage for dismantle, I think it will take time. So I have to, if I have built, I have erected house, then there is some from the turnover, I have to call the mysteries and all those some those.
In Dapo, there's no mystery.
That there is, but there is this stays landslide and raining. And moreover, our road communication is not proper in proper this state. So maybe given 6 month time.
6 months time?
Yes.
No, we can't keep the bail petition
No, it's
pending for 6 months.
for damaging for this, if I have erected for RCC building, this is not easy to, if I have erected.
Then we will dismiss your case.
My lord, this
You remove this column, you require 6 months. Only the iron pillar is erected.
okay, maybe given some 2 month time, maybe given, that will be.
We can give you 2 weeks.
My lord, that will be actually present this accused person is having sick person, so I think still not still is medication under the doctor. So let him cure little bit proper.
Have Mr. T. Dukam, learned counsel for the petitioner, and Ms. T. Zini, learned APP. This is an application under section 438 of the Code of Criminal Procedure, praying for granting pre-arrest bail to the applicant in connection with Daporizo PS case number 26/2023, registered under section 3 of the Prevention of Damages to Public Property Act 1984. Paragraph. The opposite Daporizo PS case number 26 of 2023 was registered on an FIR received by the officer in charge police station Daporizo on 6/7/2023. Laws were the project director DRDA Upper Subansiri district Daporizo, alleging that the petitioner has encroached upon DRDA go down number 1 and SP type 2 quarter allotted to Dapo Ane Cluster Level Federation, Upper Subansiri District. At all ZPC office, isn't it? At all ZPC office. And thereby constructed a RCC structure after dismantling and destroying the government structures, so properties. Full stop. This court by an order dated 25/7/2023 while calling for the case diary had granted the petitioner the privilege of interim pre-arrest bail. Full stop. Pursuant thereto, it is submitted by the counsel for the petitioner that the petitioner had appeared before the IO, had appeared before the IO and wherein formal arrest was made and the petitioner was allowed to go on interim pre-arrest bail on a bail bond of rupees 20,000. With on 20,000 in terms of the order of this court dated 25/7/2023. Also, the paragraph the case diary called for has been produced by the learned APP. Also, on perusal of the case diary. Well, just not the case diary produced supports the allegation made in the FIR lodged by the project director, DRD Upper Subansiri District, Daporizha, Pusto. The case diary also discloses that the petitioner has raised what is this called? A petitioner is undertaking a
Post-traumatic stress disorder.
Petitioner is undertaking a construction of RCC structures on the after dismantling the government quarter. Also, on being appraised about the materials, on being appraised about the incriminating materials found against the petitioner in the case diary, the learned counsel for the petitioner, Mr. Dukam, has fairly submitted that the petitioner may be given some time to dismantle the RCC structures constructed by the petitioner. At all JPC office after dismantling DRDA Gordon number 1 and SP type 2 quarter. Full stop. Para. As prayed for by the learned council for the dismantling, no? So that the said premises is handed over back to the appropriate authority after the same is dismantled. Also. As prayed for by Mr. Dukam on the council for the petitioner. We'll give it 3 weeks time. 3 weeks time is given to the petitioner to remove the RCC structures constructed by him on the premises of DRDA Godown number 1 and SP type 2 quarter at all ZPC office. Daporijo. It is Daporijo. At Daporijo, Upper Subansiri district. Post of. List it after 3 weeks. On which date? Up to the CD case diary, huh? So again be produced by the learned APP. Also,
Protection will be,
return the case, huh?
protection will be continued.
Interim pre-arrest bail granted earlier shall continue till the next date of listing. Return the case diary. List it after 3 weeks. I don't know, 5. None of yours for the petitioner. Heard Ms. T. Zini, rather than APP for the state. In view of the law listed after 8 weeks.
Please, Your Lordship.
Yes,
I'm appearing for respondent number 1 to 5. In here, Your Lordship, the petitioners, they were directed to file an additional affidavit.
regarding what?
Yes. That was passed on the 5th January, when the notice of motion was issued. On that day itself, they were directed to file an additional affidavit, bringing on record the order of ADC, on pursuance to which CEO of Istana has passed and summoned order.
Yes, what is?
My lord, according to last order, last direction, I have taken step respondent number 6. And
affidavit is yet to be filed. And regarding this additional affidavit, my lord, I'm not very much aware of this case. So unfortunately, my senior, his sister has passed away yesterday, and he is now there at Chibuta for funeral service, my lord. So regarding this additional affidavit, let the leading counsel maybe answer in next list.
When he will be available? 2 weeks, 3 weeks?
3 weeks. Yeah.
3 weeks, okay.
Yes.
On the prayer of Mr.
El Takam.
El Takam counsel for the petition listed after 4 weeks.
Yes.
Oh,
Oh, nice.
ah, rest steps. Yes, Mr. P. Padu. B. Padu. Why don't you come in the mic? B. Padu.
Yes, B Padu.
Learned counsel for the petitioner. Padung submits that press steps for service of notice upon
Sole respondent.
sole respondent directed to be taken by the order dated 36/20/23 has not yet been taken, for which he prays for and is granted 1 week further time to take press steps for service of notice upon the sole respondent by registered post with AD as well as by usual process, failing which the interim order passed on 30/3/2023 and the subsequent extension thereof by the order dated 23/5/2023 and 36/2023 shall stand vacated without any further reference to this court. Listed after 6 weeks.
Interim order.
Full stop. Interim order passed on 30 so and so, extended by the order of this court dated 2 dates which we have mentioned above, shall stand extended till the next date of listing, provided the press steps for service of notice upon the sole respondent is taken as directed herein above.
Yes.
Item number 8. Mr. Padum. Okay, Mr. Koyam, what is it?
In the previous hearing, time was granted to file at Bokalatnama matter. No,
Oh.
responding.
Since you worship, the respondents are senior citizens and they are not able to come here and they are at their hometown. So your worship may kindly fix after 6 weeks for filing of reply.
What are you challenging here?
My lord, they have filed a condemnation for petition for condemnation of 184 days, I think. Just a second. 184 days. And the delay has been condoned with a condition for payment of ₹6,000. I am challenging the said order that there is a provision under Limitation Act for imposing fine to condone the delay.
He is praying for 6 weeks time.
4 weeks will be sufficient.
Okay, we guarantee 4 weeks time.
Then maybe 5 weeks.
5 weeks.
Okay, no problem.
Mr. S. Counsel for the petitioners and Mr.
Jiva sir.
G. Vasar.
Yes.
And the counsel for all the respondents.
Yes.
For respondent 1, 2, and 3. Who prays for further 5 weeks, who prays for and is granted further 5 weeks time for filing of a Vagalatnama on behalf of the respondent. Okay, list it after.
She is trying to file affidavit.
Along with the Wakalatnama.
Vagalatnama,
Yes.
okay. All right. We'll say, okay.
Reply.
File affidavit along with Vagalatnama. Okay. List it after 5 weeks at Bedford.
Number 9.
My lord.
Yes.
My lord, in this matter, I have filed the affidavit in reply and service copy today. May I pray that this matter may be listed for admission hearing next week?
Admission hearing.
Yes,
What is, this is criminal petition,
criminal petition.
not yet admitted.
There is an interim order is there, Your Lordship, protection, Your Lordship.
Yeah. What is the matter about?
Watching of a proceeding, my lord. Complaint case.
Complaint case.
Only 2 aspects has to be looked into here. In my humble understanding, this is very simple. 2 issues is there. One is whether the procedure has been followed by the learned court below or not. That is the first issue. And second is whether prosecution sanction under section 197 is required in this case or not. That is only 2 issues here.
Okay. You are representing
Respondent number 2 and 3.
2 and 3. Who are they?
They are the respondent number.
Complainant is the
Complainant.
wife and victim.
A complainant and victim. What are you alleging against this, against the petitioner?
The prime allegation is that, Honor, on the day of incident, fateful day of incident, Honor, I was arrested without any Honor information given by any person, without any FIR. I was arrested and taken to the police custody, and thereafter I was Honor brutally tortured in the police custody by the petitioner. Thereafter, Honor, a FIR has been registered for my wife, Honor, on my behalf, and thereafter this FIR was investigated, and the police has submitted final form in the tune of closure report. And after closure report was sent to the court, Your Honor, in the JMFC Anjao. The JMC Anjao has found sufficient material against the petitioner and took cognizance upon the matter. And thereafter, Your Honor, section 330 has been inserted by the Your Honor trial court, learned Your Honor JMFC court, and committed to the Court of Sessions for trial against the petitioner. That's why, Your Honor, the petitioner, Your Honor, raised here in this case, Your Honor, 2 points. that the cognizance order which was taken by the learned JMFC Anjao was illegal in the in the law of land owner, and as well as the petitioner is protected under section 197 of the CRPC because he is a public servant.
Hmm.
In this case, Your Honor, one thing
You lodge a complaint before the magistrate.
yes, no, Your Honor. Protest petition.
Complaint case.
Yes, Your Honor.
Okay.
Complaint case.
Much.
Now, here in this case, one thing I would like to draw the attention of this honorable court, Your Honor. The petitioner has never approached the learned lower court, Your Honor, the session court Teju, Your Honor, at the time of framing of the charge or any type of, Your Honor, any point of, Your Honor, trial that I was protected under section 197 of the CRPC. He has direct approached the honorable, Your Honor, High Court, Your Honor, before this honorable court. And by taking the, Your Honor, stay order, Your Honor.
That's totally wrong submission, madam. No,
He is asking for some time. He is asking for some time.
Okay, time may be given, Your
Huh?
Honor. Time may be given, my lord.
Okay. 2 weeks?
I have no problem.
Oh.
Fixed date may be given.
Fixed date may be given.
When?
According to both of their convenience, Your Lordship.
Sometime in September? Mr. D. Lazi, on a counsel for the petitioner. Mr. T. Ete, APP for 1, and Mr.
MK Singh.
M.K. Singh, on a counsel for respondent number 2 and 3. On the prayer of another counsel for the parties listed on
8-9.
8th September. Okay.
Yes,
Not September. You are arrested in connection with which case? Which section?
Section 330 of the IPC.
No.
Your case, in
You
your
are-
case, you have been arrested, which you were arrested.
You were arrested in connection
Under
with,
section 379.
okay, theft case.
Yes.
What was the subject matter of theft?
Honor,
What was the subject matter of theft, Alice?
machine,
Machine, what machine?
generator,
generator.
64
Okay.
kV generator of the company.
Okay, all right. 8 of
Much obliged.
Interim order, madam, I can give.
interim order passed. I'll just continue till the next date of listing.
Obliged.
Chapter number 10 and 11.
Please, Lordship.
Yes.
Lordship, in this matter, BM Mr. has been engaged newly counsel in main criminal review petition.
Who has been engaged?
BM Mishra,
B.A. Misra.
yes, yes. He
Yes.
is filing a wakalat nama within this week. So matter may be released after 2 weeks.
What is this IA?
This is for vacation of expert interim order dated 9 February 2023.
That is filed by you.
Me.
Okay.
And it was filed on 17 April. Thereafter, matter was listed on 18. Copy already served. And they have taken time on 18. Thereafter, on 16 May, 8 June, 24/7, and then 4/8.
What was released on Zimba?
Certain amount, my lord. Actually, what happened, my lord, in this case, petitioner, on the pretext of giving some contractual work amounting to more than 100 crores, he fraudulently obtained more than 5 crore rupees from me. So accordingly, I have lodged the FIR. And thereafter, during the investigation, some accounts of the petitioner, it was frozen. And in the meantime, we have filed JIMA application before the London JMFC, and that was allowed. Not entire amount, but some amount that were frozen. And in the meantime, we are made to file an indemnity bond also for the temporary custody of those amount. And thereafter, certain amount we have received. In the meantime, they have approached before this honorable court by filing this criminal revision petition number 3 of 2023. And accordingly, on 9 February 2023, this honorable court has directed not to release the amount, the remaining amount
Hmm.
by way of ex parte interim order.
He's praying for some time. Who is appearing? Who is appearing in this case?
BM Mishra Lordship.
BM
Mishra.
Misra.
Yes, Lordship.
Last occasion also they have
Earlier, who was appearing?
D. Hussain and I.S. Laskar.
Hmm. How can you keep changing your counsel? You may change your counsel, but he has to appear.
Last order
time,
also, my lord.
D. Hussain has written the brief. And newly engaged counsel needs some time to prepare. 4th August. It was fixed on your fixed at your instance.
Again today, they have not filed any wakalas.
When BM Misra will be available?
Sorry, Lordship, I am completely unaware of this matter.
You speak in the mic.
I am having instruction by telephone.
So we vacate the order and hear your criminal revision petition at your convenient time. Okay. Huh?
Sorry, Lordship.
Huh?
Sorry, Lordship.
We'll vacate the stay order and thereafter hear the petition at the convenient time of Misra.
Sorry, Lordship. No idea, Lordship.
No idea. What is to be done?
Case last opportunity, my lord, and kindly it may be reflected that in the next that if they don't appear, then I will be disposed.
Oh.
They have already filed a affidavit in opposition also.
Your name?
G. Tai, Lordship.
G.
Tai.
Tai.
Yes, Lordship.
Mr. G. Tai. Learned counsel for the opposite party. Stock revision petitioner
Yes, Lordship.
informs this court that Mr. BM Misra,
Yes, Lordship.
learned counsel,
Yes, Lordship.
from where?
He is from Guwahati, Lordship.
Guwahati,
Yes, Lordship.
Guwahati High Court
Yes,
from
Lordship.
Guwahati has been engaged to represent the opposite party, so revision petitioner, for which he pressed for some time. Mr. K. Tama, learned counsel for the applicant, stroke opposite party. Applicant, stroke respondent in the revision petition has however pointed out that various adjournments have been taken on the similar ground. As a similar ground and no further adjournment be given to the opposite parties, the revision petition. Yes. Having heard the learned counsel for the parties, let this application be listed after 2 weeks.
Yes, Lordship.
4th of August, September.
4th September.
4th September.
4th September, okay.
Okay, Lordship.
Okay. Then this application will be listed on 4th April, September. Which is the date, which is the date agreed to by the learned council, by both the learned council. List accordingly.
On that day, my lord, endeavors will be made to dispose
No,
of
that court will decide.
Deeply obliged.
highly obliged.
Please, Your Lordship.
Yes.
The main revision petition notice was issued on 11th month. But due to paucity of time, the IA could not be considered on that day. This IA is for the suspending the order passed by a learned appellate court, that is district and session judge. This revision petition, in this petition, we have challenged the conviction that was done by the learned CGM SEPA, against which appeal was filed before the session court. Session court upheld the trial court's judgment and order. Judgment and order is in this page 66.
But this is an application on the 397.
Yes, madam.
You're asking for suspension of sentence.
Yes, madam.
How under 397 we can suspend?
In main, we have sentence means the order can be suspended by order 397. Man. The Lordship may see, and we have filed that main revision under 401. Man. 401 of CRP.
397 is the revision.
No, I admit to it, man. But 401 is.
Read with 409. Sorry, 401.
No, I get your Lordship, madam. I'll just show you Lordship, madam. 401 and 397. There's a slight difference, madam.
Okay. So according to you, revision is under 401.
Yes, madam.
Not under 397.
No. But in this IA, what we are praying is suspension of actually the order, madam. Appellate court's order.
Appellate court's order?
Yes, madam.
Then what happens?
Which has allowed the sentencing also, judgment and order.
Just a moment.
Yes.
Just a moment. You are asking for suspension of the judgment.
Appellate court's judgment.
Appellate court's order.
Yes.
If the appellate court's order is suspended, then what happens?
Then till disposal of revision petition, the petitioner will be on bail, which he is already on bail. By the convicting court has already granted him bail.
Convicting court has granted you bail.
Yes.
For how much time?
For till 18 of this month.
Till 18 of this
Yes.
month. So then you will remain on bail till 18?
No. Yes, madam. That is for approaching this honorable court, madam.
So now, what are you praying for under 397 here?
We are praying for suspending of this order, madam.
Which order?
Page 66, madam.
Appellate
Yes.
order?
Madam? Yes.
Appellate order?
Yes, yes.
If assuming we suspend the appellate order,
Yes, madam.
then what happens?
Definitely, madam.
Conviction by the,
Conviction and sentencing, that would be stayed, madam, automatic.
how it can be stayed?
Because
The conviction by the trial court survive, then
No.
that will operate.
against the trial court's verdict, madam, we have approached the appellate court, madam. Now, appellate court has upheld the verdict of trial court, madam. Now we have to challenge the appellate court's order, madam.
Not the
In
trial court's order.
No, madam. Because against the trial court, we have already approached before the session, district and session. This is against the appellate court's order, madam. And
Okay.
against appellate court order, we cannot file an appeal, madam. That's why we are coming up under revision.
Let us see whether the judgment can be stayed.
Yes, madam. That's
Yes.
now,
yes.
madam, that's why, madam,
Before that, you wanted to point out 401.
401.
What is the difference?
my lord, I'm reading 401, man.
Yes.
The High Court's power of revision, man. In the case of any proceeding, the record of which has been called for by itself or which otherwise comes to the knowledge, the High Court may in discretion exercise any of the powers conferred on a court of appeal by section 386, 389, 390, 391, or on a court of session by section 307, this one. And when the judges comprising of court revisions are equally divided, this here, my lord, there's no provision for stay, man, suspension, man, under 401. But at 397, your lordship will see same revision power, man. The calling for records to exercise power of revision. The High Court or any session court may call for and examine the record of any proceeding before any inferior criminal court situated within his or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order, my lord. It includes not only sentence, order recorded or passed, and as to the regularity of any proceeding of such inferior court, and may when calling for such record, direct that the execution of any sentence or order be suspended. Sentence or order be suspended. And if the accused is in confinement, that he be released on bail or on his own bond pending the examination of the record.
Okay, then what is,
So my lord,
what is, then what is
my lord, like,
389?
yes, my lord. That's why I have read 401, my lord. Under 401, your lordship has the power to pass order under 389 also. That's why I pointed out this 401, man. Lordship may kindly see 386, 389, 390, and 391. This under this, your lordship can pass under this 401 orders under which is 389. 389 is also suspension of
So since,
sentencing.
yes, since the revision is preferred under 401,
Yes, ma'am.
which empowers to pass an order under
89 also,
389.
yes. Yes, ma'am.
Why not 389 and why 397?
What we thought is, my lord, under 389, your lordship's power is more, my lord. 389 would be bit specific, man, under this revision. In 409, your lordship has vast powers, my lord,
How?
to pass order under 389 also, man.
You agree 389?
Yes, ma'am.
Pending any appeal
Yes,
by
yes.
a convicted person,
Yes, ma'am.
the appellate court may, for reasons to be recorded by it in writing,
Yes, madam.
order that the, okay, this is by the
Yes, appellate court, madam.
appellate court,
Because
not by the revision of.
No, madam. That's why we have intentionally preferred the 401 and to file at 397, madam. Because this is specifically for appellate court, madam. But under 401, your lordship can pass order under this provision also, madam.
Okay,
That's why, madam.
yes. That is.
So lordship, in page 74 is the order, madam, the bail that has been granted by the convicting court. $389 is specifically for appeal, madam. That's why, because this is division, madam. Page 74 is the madam, bail or order, madam.
74.
Yes, madam.
For 30 days.
Yes, madam. Here, your lordship will clear, say, who is convicted under section 352, 387, 34 IPC, read with section 511 IPC to undergo simple imprisonment of 2 years with a prayer to enlargement of bail. So, So since last para, since the sentence is not exceeding 3 years, this court is inclined to grant bail to the applicant convict, namely Sri Aga Nampa, to enable to file appeal before Honorable High Court. Accordingly, convict Sri Aga Nampa is allowed to remain on previous bail with the same terms and conditions for a period of 30 days from today. So he was the whole during the trial, my lord, and he was on bail, my lord. So filing this application, the learned convicting court has already granted him bail, my lord.
Okay.
Now, my lord, in this
What is the sentence?
sentence, 2 years imprisonment, my lord, simple imprisonment.
2 years.
Yes.
Where is that?
My lord will say page 68, my lord, paragraph 4.
68.
Learned Court of CGM, SEPA by judgment and order dated 1/4/2020 has convicted the
2 years or 2 months?
My lord, no. 2 years.
2 years.
Yes.
Where it is?
Otherwise, 2 months, my lord, there's no appeal provision, my lord.
Okay. Where is it?
Paragraph 4, my lord,
Yes.
page 68.
Uh.
Learned Court of CGM, my lord, by
Uh.
judgment and order dated 1/4/2020 has convicted the appellant Aga Nampa under section 352(34) IPC and sentenced him to undergo simple imprisonment for 2 months. He is further convicted under section 387(34) IPC rewrite with section 511 IPC and sentenced him to undergo 2 months. This is incorrect. We have already prayed there, my lord, for correction of this 2 years.
It is 2 years.
Yes, 2 years.
Okay.
Otherwise, 2 months, there is no appeal to before the session court. We cannot appeal.
Okay.
So that's why, my lord, the main section is 387, my lord, extortion, my lord. For this 2 years has been given. So what we are in this revision, what we are praying is, my lord,
Where you corrected this?
my lord, we have this is the, my lord, trial court advocates inform me, my lord, they have filed application before the. I'm not sure about it. But otherwise is 2 years. Otherwise there couldn't have been appeal, man. 2 months, there's no appeal.
Where is that correction order?
No, man. That
Not yet
no,
corrected.
No, we have, man, judgment of the trial court also.
You have not annexed yet.
No, man, because records has already been called for by in this on 11th month. The entire record. So I'm
Yes.
the way found on page down below, page 25 of 28.
Yes.
Yes, 58, paragraph 58.
Hmm.
Aga Nampa is sentenced to undergo simple imprisonment for 2 months for offense under section 352(34) IPC. He is further sentenced to undergo simple imprisonment for 2 years for offense punishable under section 387(34) IPC read within section 511 IPC.
Okay. Then what is to be stayed?
Malad,
What is to be
the order passed by the learned the
Appellate court.
Appellate court. Yes.
okay.
Order dated 8/6/2023.
On what ground?
Malad, first of all, Malad,
Extortion is very
extortion is not made out of in the entire trial, Malad.
Uh,
The statement of the main victim, Malad. That's why, Malad, I'll show the extortion when putting someone into fear and demanding property, anything valuable thing, Malad. First, one has to put one into fear and demand property, valuable property. That
you demanded with sword.
no, man.
Huh?
That is not there. Your Lordship, that's why I've only I've shown the examination of victim. Man.
FIR was to that effect.
FIR was given by some other person, man. The Bajar Welfare Committee or some commerce man, something like that. The victim didn't give the FIR.
Yes. Yes. PB, what do you say?
Yeah, Lordship, the statement of the accused Lordship and there his accomplice Lordship, they have Lordship clearly stated that he was with him at that night. And he slept him, Lordship, and Lordship, the CCTV footage also, it revealed that Lordship on that night, Lordship, when the incident took place, that the accused Lordship, he was with that man accused Lordship. The two of them, Lordship, assaulted the victim. It is covered in CCTV also. And Lordship, here the statement of the accused Lordship in the page 44, 313.
What is the law on suspension of sentence?
Lordship, it can be Lordship heard Lordship during the pendency of the Lordship, the appeal Lordship,
During the pendency of
appeal Lordship, because this is IA Lordship for the suspension. And appeal Lordship is already there, the records have been called for.
So see, there is a provision for suspension of sentence. That is why he has come before us.
Lordship,
What is the law on suspension of a sentence?
Lordship, here Lordship, after the perusal of the records, Lordship, if Lordship deems fit, Lordship, if Lordship is satisfied that the suspension can be granted, then it can be allowed, Lordship.
What is the law on suspension?
First of all, but prima facie is, there should be some merit in the revision petition. If some prima facie case should be made out.
Yes.
And we have to see the punishment which has been imposed by the court below.
Okay.
In the heinous crime, Lordship is aware, 389, mandatory the notice to the public prosecutor to allow them to file affidavit for suspension of order. Not in cases where sentence is below 3 years. 3 years and below. No notice is required. So, and first of all, the prima facie case has to be made out by the revision petitioner. Second, the sentence which has been passed. Here only 2 years.
2 years.
And that is also 387. Otherwise, for 511, which my learned friend is saying assault and all that. This 511, that's punishment is 2 years, 2 months has already been given. That is not appealable. That's why we are concentrating on 387.
No, what is the law? What is the law on 2 years? 2 years imprisonment.
Mandatorily, that's why this is in such a punishment which is of 3 years and below, is naturally unless extraordinary circumstances is there, the person who is already on bail, during the trial who was on bail and who has not violated any terms and conditions of bail, generally bail is sentence is never rejected. It's always suspended.
Let us see 387.
389.
No. IPC, you have been convicted on extortion. 387.
Yes. It reads, putting person in fear of death or of grievous hurt in order to commit extortion. Who?
Yes.
Yes. Who are in order to the committing of extortion, puts or attempts to put any person in fear
of death
or of grievous hurt to that person or to any other shall be punished with imprisonment at the description for a term which may extend to 7 years and shall also be liable to be fined. May extend to 7 years.
What was the evidence against you in the trial court?
That's why, what evidence which they have stressed, is
which the court is relied on.
Yes, first of all, 313 statement and of course victim's statement. That's why I wanted to come to the statement given by the victim. Victim is the sole eyewitness whom extortion or anything has been put.
Yes, let us see that.
It's page 37, madam.
37.
Yes.
How many victims? Only one.
Only one.
37, yes. Sanjay Kumar.
Yes. I'm fully aware of the reason of my attendance in the court. I have been residing SEPA for the last 23 years. I've been running the present shop since 2004, sometime in the month of April 2021. June Rakha, who I'm new, since his childhood, they met me in market. He asked me for financial help. June Rakha is the co-accused man, whom the sentence is only for 2 months. That's why he's not here.
Yes.
Childhood met him in the market. He asked me for financial help. I refused as I had no money. After 5 days, 6 days, he again came. Again, after some days, I came in a vehicle. Sorry, he came in a vehicle, and one local was driving the vehicle. I again refused. Again, after some days, June Rakha, along with Aga Nampa, whom I frequently see in SEPA, came to my shop at around 10-11 and asked me money. I again refused. They left in the evening after closing the shop. As I was standing outside the shop, somebody told me that a person was calling me from a vehicle. I went near the vehicle, which was an Alto car. June Rakha was seated in front seat. He asked me if I managed amount. This is the co-accused, not the accused person. As I was talking to him, Aga Nampe came from behind aggressively and hit me from behind. After he kicked me, I pleaded him not to do so. I had nothing to do with him. Since he appeared to be very aggressive, I went away towards my shop to avoid him. Thereafter, they seemed to be leaving the place. Suddenly stopped. Aga Nampe alighted from the car, opened the dicky and took out dao. He chased me holding a dao. I ran towards the Divana Hotel. Bouquet Fago, who knew me, was approaching from the opposite side in his Scorpio vehicle. He stopped and asked me why I was running. I told him I got into his vehicle and came back to my shop. By that time, the miscreant had left the place. I was assaulted, but I did not receive any serious injury. I informed the matter to my landlord, Sri Loli Dolo, who informed the matter to the policeman.
Yes.
So, yes, ma'am. Here,
You chased him with thou.
no, that's why I'm frankly submitting the 511, the assault part, madam. That's why I'm not on the assault part, madam. Here, now, Lordship may see the cross-examination.
Okay.
Aga Nampa actually came to my shop only on the day of the incident and not prior to that. Aga never asked money from me except for assaulting and chasing me. But how, prior to the present incident, June Rakha never assaulted me, intimidated me. It is true that June Rakha frequently asked money from me. June Rakha is a different person, madam. It's not me. I'm Aga Nampa. So, when I have not demanded anything, the extortion cannot be applicable in this manner. First of all, I must put someone into fear, or of death or grievous hurt on the 387. For committing extortion. I have not demanded money. It's clear from the statement of the victim himself.
Right.
So therefore, 387 is not made out. The learned court has also relied on the 313 examination of the accused person. That is page 44. Page 44, man.
All right.
The question was PW3 has PW3 same the victim. because everything was relied on the victim's statement. Here, the question was put, madam.
Well, it had Mr. P. Tapo, learned counsel for the applicant, and Miss L. Hage, learned APP for the state. This is an application under section 397
Yes, ma'am.
of the Code of Criminal Procedure 1973 for suspension of judgment and order dated 8/6/2023, passed by the London Sessions Court, West Cumming District, in criminal appeal number 01/2022, Aga Nampe versus State of Arunachal Pradesh. And to release the petitioner on release the petitioner on release the applicant
Yes,
on previous bail granted
on
by the order dated
7/7,
18/7/2023 by
convicting court, CGM court.
by the
Sepa.
Court of Chief Judicial Magistrate Serpa. Passed in bail application number 37,
Yes, ma'am.
2023, allowing the petitioner, allowing the applicant to remain on bail for 30 days from 18/7/2023. Is not it?
Yes, ma'am.
To enable the applicant to prefer an appeal against the
Judgment and order dated 8/6/2023.
he has not mentioned it.
It's not mentioned, but definitely it would be against the 8/6/2023.
Against the judgment
Order dated 8/6/2023.
and order dated
2023.
8/6/2023. Passed in.
Criminal appeal number 01 of 22.
What is that?
Page 66, man.
Passed in.
First, ma'am. Criminal appeal number 1 of 2022.
Passed in criminal appeal number 01
Yes, ma'am.
stroke 2022 by the Sessions Court
Yes.
at Bomdila, upholding the conviction of the applicant under two parts, no? Under section.
Yes, ma'am. First is on 352.
Under section 352
Oblique
34 IPC, sentencing the applicant to undergo simple imprisonment of 2 months,
Yes. Ma'am. And another is 387.
and also under section 387 34 IPC, read with section 511 IPC, and sentencing the applicant to undergo 2 years Simple imprisonment.
Yes, ma'am.
2 years. Simple imprisonment. Did we mention the court, CJM? Okay. We did not, in GR case number, no? GR case number 18/2021, arising out of SEPA, PS case number 17/2021.
Yes.
First. Upon. Revision has been admitted.
Yes, ma'am. On 11th it was admitted.
Okay. The revision petition filed by the applicant stock petitioner being what revision?
Revision petition number,
Being criminal revision
18.
number 18 AP of 2023, challenging the judgment dated 8/6/2023, passing criminal appeal number 1/2022. In connection with SEPA PS case number 17/2021. In GR case number 18/21. Has been admitted for hearing. Also, the applicant stock revision petition contents that though contents that from the contents that the victim who was examined as PW,
Two, apologies.
page number,
Three.
page number
Page number, is page 37, ma'am.
37.
PW3.
Yes, the victim who was examined as PW3 in the trial, though had stated that the applicant had chased him by holding a dao in his hand. Which made him to run towards the Divana Hotel. Wherein he was stopped by one Bouquet Flago, who was approaching from the opposite side in his Scorpio vehicle. Whereafter the whereafter the miscreants within bracket, applicant had left the place, comma, there is no statement made by the victims of PWD3 that as a result of the victim stroke PWD3 being chased by the applicant, he was made to deliver to any person, any property or valuable security comma, so as to attract the offense of extortion as defined under section 383
Yes.
of the IPC. First off, upon consideration of the contentions raised as above, and also having regard to the fact that the applicant was on bail during the trial of the case, and no instance of any abuse of the conditions of the bail having been brought to the notice of the court at any stage, it is hereby provided I'm of the view that and also having regard to the fact that you were arrested,
No,
never arrested,
no, I was previously arrested on bail, my yes.
on bail.
Yes.
You remain how many days in custody?
My lord, 15 days only.
Okay. And also having regard to having regard to the sentence of imprisonment for 2 years that has been passed by the convicting court. This comma, I am of the view that this application be allowed. First, accordingly, pending disposal of the revision petition, the execution of the sentence passed by the appellate court.
Yes. My lord, order passed by, my lord, that will be order passed by appellate court.
Huh?
Order passed by the appellate court.
Sentence was imposed by the trial court.
My lord, your lordship is suspending the order, my lord, appellate court's order.
Lordship, CJM court order was upheld by the session court, appellate court.
Okay. Execution of sentence passed by the trial court, which was upheld by
Yes, ma'am.
the appellate court, namely the sessions court Bomdila, in case number, in criminal appeal number
01 of 2020.
2023. In anything
In
further?
connection with this, that's in connection with the present appellant only, madam, not against the other.
Yes, where is that? That
Page 66, madam.
66.
Yeah.
Yes.
There are two appeals.
In connection with
01 only.
SEPA PS case number 17/2021, in GR case number 18/2021, shall stand
Criminal appeal number 122.
Yes, this is.
Yeah,
that is-
shall stand suspended insofar as the
Petition is concerned.
applicant is concerned.
Obliged.
Highest of dispose.
Lordship, although Lordship, that sentence is 7 years, but court already, Lordship, they have sought leniency, Lordship,
Oh,
have granted 2 years plus.
Malad, that there is no question of enhancement now, Malad. For that, the state ought to have filed the application under 377. Malad. Enhancement can be done only under 386
No, no,
CRPC. Malad.
leniency has
So-
been granted, Lordship, but 7 years they have, only 2 years there.
No, Malad, to go accuse only 2 months sentence, my lordship is, if your lordship sees, Malad.
That
To me, is 2 years. And both under 334. Anyway, Malad. Obliged.
but you said there was a correction application filed
No,
before
Malad, the trial court advocate Malad informed me. I'll just confirm, Malad, before next date, Malad, whether it has been corrected or not. They will, but definitely, Malad, records have been called, Malad. They will say.
because
that.
we have referred to as 2 years, but on the record it is 2 months. No?
Malad, that's why I've shown the conviction order passed by the trial court, Malad.
All right.
Obliged.
What is this?
Lordship, morning they have made a mention and your lordship has directed them to apprise the court on the status of the case. present
Oh,
status.
this time G Talo has come.
Yes. Yes, Lordship. Lordship, the conducting council.
Criminal review, yes. What is this matter about?
In my limited understanding, Lordship, this matter challenges the charge sheet filed before the learned JMFC court, Lordship. It is
Okay.
pending trial.
What is the stage of the trial?
Evidence, Lordship.
Evidence
Evidence,
still going on.
Lordship. It's on 468, your lordship, CRPC.
460, what
Yes.
is 468?
Regarding your limitation for your lordship, institution of criminal proceeding, your lordship. In certain offenses, your lordship, where punishment is up to 3 years, or certain offenses is there, where the case has to be filed within your lordship, a limitation period has been within 1 year or within 3 years. Here, your lordship, according to them, the
Yes.
period for computation for limitation will be from the day of offense and till the filing of the charge sheet, your lordship. What their condition is. But so far as the prosecution is concerned, what we are, your lordship, saying as per the settled law, that it will be computed from the day of offense till the filing of the complaint, whether it will be before the police or before the concerned magistrate, your lordship.
Okay.
That's the issue.
We are praying for the adjournment.
Yes, lordship.
Again. How much time?
After 1 week, lordship.
After?
1 week.
1 week? Okay. In the prayer of Mr. G Taro, counsel for the petition listed after a week.
Deeply obliged.
Yes,
I'm on behalf of the Appellant, I'm for the appellant. It's a MSc appeal. Said, we are challenging the impugn judgment and award passed by the learned court below. Most particularly on the, since the learned court below has passed an impugn judgment and award against us for payment of claim amount in favor of the claimant. So we have challenged that actual liability is bear by the OP number 2, who is the insurance company. Whereas during the incident has been happened, at that time I have the active insurance policy with the OP number 2, duly paid the premium. So I'm challenging that the OP number 2 is the actual liable to be paid a claiming amount by the claimant. I'm not. In respect to such, Your Lordship, I have annex insurance policy documents in my MSc appeal, page number 58. Page number 58 in the first column here.
You are the owner of the vehicle?
Yes, I am the owner of the vehicle.
What had happened?
Actually, during the
Where is the insurance policy?
insurance policy,
Yes, page number?
page number annexer 6, page number 54 it was.
54.
Yes. The most particular I'm pointing out for the premium I have paid for the operations operator with regard to the operator yourself. In this case, Your Lordship, the learned
What
court
kind of
will,
a vehicle? What kind of a vehicle?
is an excavator machine. It's a machine that used to construct a formation cutting for formation cutting. It's Falkland. We used to say
Falkland.
Falkland, yes. Actually, it's a machine used. The person who, someone who operate yourself, the such person called as operator, not as driver yours. But the learned court below has made a manifest error while considering the distinction between the term driver and the operator yours. Since in my case, driver will not apply yours. Since it was a machine yours.
Okay.
It was a machinery. So person who operate is called a operator, not driver. But learned court below has come into the conclusion by one trick.
It is a death case.
Yes, death case.
Who died?
Yeah. Claimants and
How?
during the construction of the road, Lord said, the suddenly the boulders roll.
Boulders.
Yes, boulder has rolled into the machine yourself. This is incident. The claimant's son has been dead. Yeah.
So it is a motor vehicle. Falkland is a motor vehicle.
It's a vehicle. It's a vehicle. Yes. It is
Vehicle.
It's a vehicle.
Okay, so it will be governed by Motor Vehicle Act.
Yes. But the person who operate call operator yours, not driver yours. But learned court below has come up to the conclusion that the driver, the person who operate the excavator is a driver. And what?
Who is for the insurance
OP
company?
number 2 has.
Yes, what this say?
So here the premium, extra premium also, that they have paid because it is a commercial package policy also. Commercial package policy. So in that case also, they have to pay an extra premium also in order to get a contractual obligation from the insurance company so that to indemnify the owner. So in this case also, the owner has paid the extra premium for the person employed for operation, not operator, Lordship. Operation, Lordship, in order to operate a vehicle, a commercial vehicle, there are engaged many people, many employees are engaged. for maintenance, loading, unloading.
Ah.
So in that case, Lordship, for maintenance and or loading and unloading, they have paid the extra premium of 50 rupees. However, Lordship, in case of limited liability to paid driver, conductor, cleaner, employed for operation, Lordship. These employees, Lordship, driver, conductor, cleaner,
Hmm.
they have not paid any extra premium, Lordship. So in this case, Lordship, since it's not necessary that under 147 that there has to be a contractual obligation, Lordship. And when there is no contractual obligation, the insurance company cannot be held liable to indemnify the owner.
Yes.
There
We
is
have
the-
paid the premium, Your Worship. Page number 58, Your Worship. May I take my MSc appeal, Your Worship.
Ah.
Page number 58.
Did you raise this issue before the,
Yes, yes, of course, we have raised.
how it was dealt with? How it was dealt with by the tribunal?
Yeah, tribunal trial court has come with the conclusion with the driver, Worship, instead of operator. But during the trial, Your Worship, claimant has also, in their application, they have said that the.
What is the
Except-
difference between operator and driver?
Yes, Lordship.
Operator also operates the forklift.
Driver in the common understanding.
Huh?
Lordship. There is a distinction between the slight distinction between the operator and the driver, Lordship, that we have to understand, Lordship.
Okay.
In the
Your
common
forklift
understanding.
was driven, it was operated by whom? Operator,
Yes,
not the driver.
not driver. Who used to operate the machine like machinery or equipments, like heavy vehicles, just like a forklift or crane, something like that, the machines, machineries or equipments. The person who operates call it operator.
Ah.
Like that, the person who drives a train, that not called a train driver, was it?
Ah.
It's called a operator, train operator, not driver.
So any accident caused by the operator, the owner will not be liable.
Yes, what I am pointing out here, my lord. During the incident, Your Worship, I have the active insurance policy, which duly paid the premium with the OP number 2, Your Worship.
That is for the operator,
covering the
operator or the
risks.
driver?
Yes, covering the risks of your. If you come to the page number 58, Your Worship, on the first column, Your Worship,
Yes.
page number 58. It
Yes.
says the additional LL to person employed for operations. In the
54.
first, yes, first line is clear that the person employed for operation, Your Worship.
54. Page
Yes,
number?
58.
58.
In the last page.
Yes.
Page number 58.
Records have come. Oh. Yes, 58.
58, yes.
Hmm.
In the first column.
Hmm.
Additional LL to person employed for operation and or maintenance and or loading and or unloading. In the first line itself clear that the additional LL to person employed for operation is the person employed for operation. That means the person who was operating the said vehicle unit. It's called an operator unit. So we have paid. So meaning there we are cover the risks of the operator units. It was not appreciated by the learned court below while praising the material record. So it's a simple issue, Lord. If I was duly have a active insurance policy which cover the risks bearing to the operator, Lord. So I'm not all liable, If I was not paid and I was not have the insurance to cover cover the risks of the operator, lordship, then I may be liable. But whereas in order to cover the such risks, unseen risks, yourself, I have already have a active premium, yourself, with the OP number 2 with the insurance company. This was not appreciated by the learned court below. And come to the conclusion with the only with the driver, despite of operator loss.
What happened in the case actually?
Actually, today the OP number 2 has to file the objection.
What
Written-
objection?
Written objection,
Huh?
regarding
Lordship, I was to take instruction from the company with regard to the conditions, Lordship, terms and conditions provided in the policy, Lordship.
This is an appeal, no objection is required. It has come up hearing.
September of last year. There was a reason on our prayer or
actually the OP number 2 is seeking again time and again for the filing of the objection.
Filing of what?
Objection.
Huh?
Objection, Your Worship.
What objection you-
In
is
regard
required?
to my MSc appeal, Your Worship.
Huh?
In regard to my MSc appeal, Your Worship,
No objection is required.
which I have raised the issue in my MSc appeal, Your Worship.
In appeal, no affidavit is filed, no objection is filed. What objection is filed? All objections have been filed in the tribunal. What objection you will file?
Lordship, because the terms and condition that provides in short term, Lordship, whether OPN, Lordship, stands for operator or operation. That was supposed to be clear, Lordship. So,
Was this an issue before the tribunal or not?
Lordship, this was an issue before the tribunal.
This was not an issue in the tribunal.
No, Lordship, the issue was there in the tribunal. This same issue was there. It was raised in the tribunal.
Why are you shying away from the mic?
Lordship.
I can't hear any one of you properly, yes.
Yes, Lordship, the same issue was raised in the before the tribunal. Lordship.
This was not raised before the
No,
tribunal.
same issue was raised before the tribunal.
It was raised before the tribunal.
Yes,
Then tribunal has decided it.
yes, Lordship.
Then we have to see whether the tribunal has correctly decided or not.
Yes.
Then where is the question of objection here? Objection, affidavit in opposition means what? That is an evidence.
Lordship.
Evidence is not permitted to be laid in an appeal. All evidence is before the trial. What objection?
Lordship, I have received verbal instruction, Lordship. I won't be filing the objection.
You will be filing objection.
No, I won't be filing the objection.
No, they are saying that.
Only last
There
occasion.
is-
Lordship,
If
only
you,
last-
if you conduct the case in this manner, it is very difficult to dispose of 2 cases in a day. Yes. What to do? He is not filing objection.
In this case, Your Lordship, since I was expecting today the filing of the objection by OP number 2, I'm not prepared at all. So
I thought-
short date may be given, Lordship. Some documents is there to be.
I thought you were arguing the appeal since you were making distinction between driver and operator.
Some material documents has to be proof in supporting of my submission, Your Lordship. So short date may be given to settle the issue, Lordship.
On the payroll and the counsel for the party, this is after 3 weeks.
Lordship, small prayer, Lordship.
Huh?
Actually, Lordship, we on the last occasion, I on behalf of the respondent number 1 had prayed for a small date because Lordship, there is a stay
Stay
since
of what?
last year. So we have been unable to go for execution,
Stay of what?
stay of the impugned judgment and award, Lordship. So that was the reason that we had sought for a small day, Lordship.
By which order?
That would be 29, 2022. 20 September 2022. So since then, Lordship, this matter is being adjourned and the stay is being continued, Lordship. So, Lordship, on the last occasion, we had prayed that an endeavor may be made that this appeal may be disposed of, Lordship, so that either way, Lordship, the matter can be finally adjudicated. Because, Lordship, they are not saying that they are not going to pay. They are going to pay, but they are saying that we are not liable. The insurance company is saying we are not liable, Lordship. One of them is liable, Lordship.
Okay, after 2 weeks,
Lordship.
any fixed date you want?
First September.
2 weeks, Lordship, after
No,
2.
2 weeks.
Much.
Much of it.